Okay, today the Supreme Court handed down a decision in an important copyright case involving ABC, the TV network, and Aereo. Aereo is an internet startup that provides a service to its subscribers to receive free broadcast TV programs over the internet. And the technology of Aereo is somewhat complicated, but the basics of it is that Aereo provides a remote antenna system that assigns each of its subscribers a very small antenna for that subscriber to elect to receive whatever broadcast shows are being aired at the time, but all through the internet. Now, the basic question the Supreme Court considered was whether Aereo service violated the copyrights of ABC and the other broadcast networks by allegedly constituting a public performance of the network's programs without licenses.
Before you get to Justice Sotomayor's second half of the question, but something more along the lines of providing hardware. Suppose a company just gave the antenna and a hard drive. That's what they sold to the user. And the user was able to use the antenna and the hard drive in her own house or apartment in order to get all these broadcast programs. What would that be a performance?
I think the end user would be doing a performance, but it would be a purely private performance, and I don't think the person that sold them the hardware, or really anybody else, if I understand your hypo, would be involved in a performance. And the answer to these hypos, I mean, this isn't something that I'm making up on the fly. I mean, it's right there in the text of the statute.
But then it really does depend on, like, where the hardware is. In other words, if Aereo has the hardware in its warehouse as opposed to Aereo selling the hardware to the particular end user, that is going to make all the difference in the world as to whether we have a public performance or not a public performance.
Well, and again, I think that goes to what I was about to say, which is that's just not because, we like one better than the other. It's because of the text of the statute Congress wrote. One of the ways that you can public perform, I mean, they start with the classic public performance, right? A singer in a concert hall, they've sold tickets, but then they say, wait, it's also a public performance if you take the singer's performance and you transmit it. And they're thinking over the airways and all sorts of other ways, if you transmit it to the public. And the definition of transmission, then, is to communicate it from one place to another. So there is a geographical aspect, if you will, built right into the statute, so that if you sell somebody hardware and all they're doing is transmitting it to themselves at their home, there's not going to be a transmission that's chargeable to the person who sold you the hardware. But if you provide an ongoing service,
so you think that
in a 6-3 decision, the Supreme Court said yes, Aereo's service does violate the copyrights of ABC and the other networks. Now, the result of that decision may not have been that surprising to copyright experts, but the lineup of justices probably was. Justice Breyer, who in the past has been quite skeptical of broad interpretations of copyright law, actually came out on the side of the copyright holders in this case, and he wrote the majority decision in which 5 other justices joined. Now, one of the most fascinating aspects of the majority decision and its debate with the dissenting opinion of Justice Scalia was over a very simple question. Who was performing the TV network's programs through Aereo service? Was it Aereo, or was it Aereo subscribers? Because this case only involved a claim of direct liability as the case that went up to the Supreme Court. Justice Breyer, writing for the majority, held that, yes, it is Aereo performing the works when it is received into Aereo's service. But Justice Breyer admitted the Copyright Act, the text of the Copyright Act, is actually unclear on this issue. So Justice Breyer relied heavily on legislative history of the 1976 Act, the Copyright Act now in force, and he interpreted the legislative history to show that Congress at that time intended to include within the definition of public performance the retransmissions of broadcast TV programs by cable companies. And therefore, Aereo's service operated much like a cable company's retransmission of those broadcast programs, and therefore Aereo service constituted public performance. Justice Scalia, however, disagreed and wrote a vigorous dissent. Scalia first attacked the court's use of legislative history as improper, and that's a long-standing position of Justice Scalia, in terms of statutory interpretation. And then Justice Scalia went on to attack the analogy to cable companies as being flawed and unworkable, a standard that he sort of likened to, it looks like cable TV. Justice Scalia said that that standard won't be workable in future cases. And then finally, Justice Scalia emphasized that unlike cable companies, Aereo doesn't actually choose whatever content the subscribers elect to watch. That's totally up to the subscribers of Aereo and not Aereo, and therefore Aereo should not be considered to be performing the works. But in the end, Justice Breyer's view prevailed, and ABC and the networks won the case. So what does this mean for Aereo, the young startup company? Well, Aereo probably has to change its business model or go out of business. It doesn't seem like there are many options left for it.
Okay, I'm going to talk today about two patent cases that the court is hearing this week. One is the Nautilus versus Biosig case, and the other is the Akamai versus Limelight case. These are two cases that the court has heard out of 6 patent cases that it's heard this term. First, I'm going to talk about the Nautilus case, which is the one that has broader implications. That case was heard on April 28, 2014, and it involved the issue of indefiniteness, or more particularly, what the standard is for holding a patent claim to be invalid as indefinite. The invention related to a heart rate monitor, and it's something that I think a lot of people have probably seen. It's on, for example, treadmills. There's a cylindrical bar, and then there's a pair of electrodes. And so the patent claim used the term, said that each pair of electrodes was in spaced relationship to each other. And so there was litigation between the two. Biosig sued Nautilus, and Nautilus said that a person of skill in the art would not understand what in spaced relationship to each other meant, that it wouldn't know how far apart the electrodes had to be. The district court agreed with that and said that the claim was indefinite and therefore invalid, and the Federal Circuit reversed. And it said that in order for a patent claim to be indefinite, it needed to be insolubly ambiguous. And that's the language that the Federal Circuit has used for many years, unless there's no possible construction that a person of skill would understand, then the claim is not indefinite.
And General Electric.
Did you have any disagreement with the standard that's articulated by the Solicitor General? He says that, a patent satisfies the requirement if, in light of the specification and the prosecution history, a person skilled in the art would reasonably understand the scope of the claim.
We may or may not, depending on how the Solicitor General would apply that standard to a claim that has 2 reasonable interpretations after the person of skill in the art reads the claim in light of the specification and applies all the interpretive tools.
The court has to come up.
That's the issue that the Supreme Court is deciding. One thing that's difficult about this issue is it's very hard to precisely define how definite a claim has to be in order to pass muster. What's clear is that the Federal Circuit's current case, this insolubly ambiguous, does not result in a lot of patent claims being held invalid. And it appears that the Supreme Court is going to reject the Federal Circuit's case, but it's unclear what the Supreme Court is going to put in its place. So that's the first case. The second case is the Limelight versus Akamai case. That case is being argued on April 30th, 2014. And that case involves the doctrine of inducing infringement, and more particularly, whether somebody can induce infringement when there is no underlying direct infringement.
Your position makes it pretty easy to get around patent protection, doesn't it? All you've got to do is find one step in the process and essentially outsource it or make it attractive for someone else to perform that particular step, and you've essentially invalidated the patent.
I don't think so, Your Honor, in the following in 2 following senses. First of all, empirically speaking, there have not been very many cases in which this has proven to be a problem. It has been a long understood principle of patent claim drafting that method claims should be drafted from the point of view of a potential infringer so that all of the steps can be carried out by that potential infringer. And prospectively, certainly, and given that this rule has been clearly articulated by the Federal Circuit now for many years, or at least several years, prospectively, the patent applicant has every incentive to draft claims from the point of view of a single potential infringer. The claim that's at issue here, there's no dispute. It could have been written in such a way that the steps would have been carried out by a single infringer, and indeed that may have been the intent. What the inventor had in mind may well have been.
When you say it would be written that way, it would be by not claiming one step in the method, I assume, which changes the whole patent.
Well, it would be to claim what is carried out from the point of view of the potential infringer. So, for example, in this case, what the method claim could have been written to say, rather than to tag an embedded object, to deliver an embedded object in response to a request for that object where in the request.
But you don't know really in every patent whether the tagging is an important part of the process or not.
Well, by definition, Your Honor, every step is material and important to the invention. That is really very deeply ingrained in the patent law.
The Federal Circuit has been struggling with that issue for a few years. The invention in that case related to a method of delivering images from a website to a user, and it used a network of distributed servers. Limelight was sued for infringement, and Limelight said that actually the users performed some of the steps. Limelight performed some of the steps, the users performed some of the steps, and therefore there wasn't one party that performed all of the steps, and the district court said in that case there could be no infringement and no inducing infringement. The Federal Circuit eventually heard the case en banc, the whole court, and issued a very splintered opinion that reversed the district court and found that in certain circumstances, even if there was no direct infringer, there could be liability for a party like Limelight for inducing infringement. And it found that if a company like Limelight advised, encouraged, or otherwise induces others to complete all the steps of a method, there could be infringement. This case has special importance for the business method and software communities where there's more claims that are written in this sort of format.
See, this is what I find somewhat troubling about your take everything into account standard. Most district judges do not see a lot of patent cases, and when they see one, it's very unusual. So you've got these patent attorneys showing up in court. They're different from other attorneys. Sometimes they particularly if it's a very technical case, they speak a different language. They do things differently. The district judge is struggling to figure out how to handle the case, and then the one party wins, the other party loses, and the party that wins says, this was an exceptional case and you should award fees in my favor under 285. And the district judge says, how can I tell whether this is exceptional? If I had 25 patent cases, I could make some comparisons. But I don't have a basis for doing that. Now the Federal Circuit has a basis for doing it.
Well, first of all, Congress has spoken and said that in exceptional cases, the district court should do this. And I think if you went back 10 to 15 years ago, perhaps the notion that district court judges haven't seen a lot of patent cases might be true. District court judges see lots and lots of patent cases. Many of those cases may not be decided on the merits. The only thing that the Federal Circuit sees are the ones that went to final conclusion. So I do think district court judges see a lot of patent litigation. I also think —
Is that really true? There are nearly 700 district judges in the country. If we had a statistic about the average number of patent cases that a district judge hears receives on, let's say, a 5-year period, what would it be?
I don't know what that number is, Your Honor. But I know that district court judges carry a widely varying docket of different areas of law and are called upon to learn the law and assess the reasonableness of those positions.
But if you leave it to the district court that way, and district court denies fees, isn't there a risk of large disparities from district judge to district judge? One will say, yeah, I think that this was uncommon, not run-of-the-mind, so I'm going to award fees, and another one will say, no, I think it's pretty standard, so I won't award fees.
We do think implicit in an abuse of discretion standard or Congress committing this to district court discretion will be some variation. We think this Court answered that problem in Kuhn, I think most particularly, in a case where the stakes were, not to belittle this case, but the stakes were even higher there, criminal sentencing. And what the Court said is, yes, there will be some disuniformity, but district court judges are better able to determine the mine run case than will the Court of Appeals, because they're able to assess the entirety of the litigation rather than one piece of it.
It seems to me we can — all that may be true, but we need to cut down to the basic issue, which is MedImmune changes all that. The idea is you're moving along with the license, everybody's happy, all of a sudden you jump into court. Why shouldn't you have the burden as the party who seeks to disturb the status quo?
Well, the reason, Mr. Chief Justice, is the reason that the burden of proof is substantive and a declaratory judgment action under the Act is aimed not to change any substantive rights, and that's why all of the decided cases in this area, except for the one below, left the burden exactly where substantive patent law left it.
Mr. Bibas, I would have thought that there's something in the copyright context that cuts against you, and that's that because of this separate accrual rule and the feature of these rolling statutes of limitations, combined with very, very lengthy copyright terms, that essentially a plaintiff can not bring suit for years, decades, and time the suit in order to maximize her own gain. That strikes me as something that's we don't usually see in statute of limitations cases. I mean, we don't have very many cases where courts have applied latches as against the statute of limitations, but that's because you can't think of many instances in which it would be considered unfair to take the entire statute of limitations to bring a suit. But in this context, you look at something that seems very different. A plaintiff can wait 20 years given the way the separate accrual rule works.
Your Honor, I think your considerations cut in favor of our position. Whether our client brings suit now or 20 years from now, she gets 3 and only 3 years damages. The evidence in this case is that creative works are worth the most right after their release. And so the value of the claim goes down. Respondents get to keep the first 17 years of profits if she waits. So she has every incentive, as the amicus briefs indicate, to file suit early. And indeed, courts can use adverse inferences against plaintiffs who delay, draw inferences or missing witness instructions from their delay. But let me point out that there are plenty of situations in which there is a delay in suit. Take Bay Area Laundry. Take a standard 30-year mortgage. The mortgagee who waits until year 20 doesn't get to claim 20 years' worth of payments. But there's nothing that debars that mortgagee from claiming payments for years 17 to 20. It would radically upend the law to say that. And to come back to your point that we don't see latches in these cases, that again cuts our direction.
Mr. Perry, before we get back to these matters, just you said to Justice Scalia, if a patent sufficiently describes how a computer will implement an idea, then it's patentable. So how sufficiently does one have to describe it? What do we want a judge to do at this threshold level? in terms of trying to figure out whether the description is sufficient to get you past it?
If I can answer in two steps, Justice Kagan. First, in the negative. What the applicant or patentee must not do is simply describe the desired result. That would take us back to State Street. That would simply say, I claim a magic box that buys high and sells low, or vice versa, I suppose. I may claim a magic box for investing. That's what these patents do.
Am I correct that no circuit has adopted the zone of interest test in the context of the Lanham Act?
No circuit has adopted it as the test for the Lanham Act. There are cases that talk about zone of interest policies, and there are cases that talk about the interests of protecting goodwill and the reputation of companies who are involved in interstate commerce. But the other tests that courts have layered onto it, I think, don't necessarily get at the direct question that is really at issue, which is, did Congress really intend for these injuries to be the subject of a cause of action?
So what's wrong with the, AGC, or the antitrust standard? So it's got 5 things. And Justice Alito just suggested that maybe that's more generous to finding standing than the reasonable interest.
Justice Ginsburg, the experience of the courts would show that applying AGC actually would be more restrictive, I believe, than a zone of interest analysis. The 2 of the factors from the AGC test are facially inconsistent with the Lanham Act. The concerns about the speculativeness of damages, at least as it relates to quantum, and the concern about the complexity of apportionment and duplicative damages cannot be applied here in a statute where Congress explicitly abrogated limits on suit related to certainty of damages. Section 43A, when it talks about a cause of action to somebody who's likely injured, that shows that those concerns about damages should not be applied. Similarly, the flexibility in the remedy that can be recovered under the Lanham Act in terms of disgorgement remedies, injunctive relief, and a party's own lost profits shows that concerns about those factors shouldn't be applied either.
Mr. Waxman, I take it that Ms. Sherry said that the FDA views itself as having a job beyond health and safety, that they view themselves as at least not thinking about competitors' welfare or lack thereof, but at least thinking about consumer understanding of labels. So if that's the case, is the determination under the Lanham Act different from the determination under the FDCA?
Very definitely, and for some of the reasons that this Court discussed in the Lexmark case, where you were talking about who can sue under the Lanham Act and who's protected, and the Court noted that, of course, consumer confusion itself can be the engine for a competitive harm. But the former is not what the Lanham Act is about, and the latter, the FDA has made perfectly clear, is not what the FDCA is about. And interestingly, even with respect to this naming provision, and, the government agrees with us far more than it disagrees with us, but our disagreement about the preclusive effect of their judgment is important. They say, okay, we spent a lot of time on these regulations and we're entitled to Chevron deference. And we think they are entitled to Chevron deference with respect to interpreting the misbranding provisions that they are, in fact, that they do enforce. They're asking, as their submission here is not just in an FDA action, enforcement action in court, will we get Chevron deference for our interpretation of what the meaning of 343I1 is. But in a Lanham Act case, we get Chevron on steroids deference. We get to basically keep you out of court entire. You're not even allowed to make that claim. That is an astonishing proposition, and it is one that there is nothing whatsoever in the legislative history, the language of the statute, or anything at all to indicate that Congress wanted.